Alrighty, folks, we are live. This is George, founder of Solo, and this is the Debt Hotline. We have with us today Yale Levy. How you doing, Yale?
Good, George. How you been doing?
Doing great. Happy to have you on the show here today. A little bit more about Yale. He is a seasoned attorney with nearly 3 decades of experience specializing in collections, creditor and debtor rights, and civil litigation. He joined Solo last year as the head of business development to enhance and improve Solo's efforts to help consumers resolve debt with collectors. He graduated from The Ohio State University College of Law, and he served as special counsel to the Ohio Attorney General's office since 2006. Is that true, Yo?
It is.
Wow, check that out. He's also the past president of National Creditors Bar Association, and he founded his own debt collection law firm, Levy and Associates. He's a well-respected and multi-state debt collection law firm. He brings his extensive knowledge in retail, commercial, and medical collections and debt settlement to Solo with the help of bridging the gap between collectors and consumers to help improve the chances of settlement for all sides. Yale, thanks so much for coming on.
Yeah, you're welcome. Glad to be here. Hope I can help.
Fantastic. Alrighty, folks. So we are talking about how to settle with a debt collector, and we'll be getting into those specifics throughout the live questions today. We have a lot of people watching the show live. If you have a question, if you want to talk with me and Yale, you have a question for us, just go ahead and call the debt hotline at 801 613 8181. That number is right here on the screen. It's 801 613 8181. All right, so you can just punch that number into the phone, and your question will get prioritized. You'll jump to the front of the queue. We have some questions from people who have written in. So, first one up we have is Kim in Michigan. I had a debt in California. The last payment was made in March 2021. I am currently in Michigan on family business, and in California, the statute of limitations is 4 years, and law states that where the debt was made is where the laws are. I'm not getting sued in Michigan for this debt. What are the laws for this? So basically, Kim's wondering, where should she be sued for this debt?
Well, again, just as my typical disclaimer that I provide when I do these talk shows like this one and the Debt Hotline, while I am a lawyer, I am not licensed in all 50 states. I'm only licensed in Ohio. I do not have a attorney-client relationship with the people that are asking the questions on this call. So all of my suggestions are hypothetical and meant to help guide people in the direction about what would happen in a hypothetical situation. I cannot provide any legal advice on the specific case that you're asking about. The first question I had was I had a debt that was created in California and I've now moved to Michigan. Can they, I'm assuming the question is, George, can they sue me in Michigan? And
That's I think the reverse. She lives in Michigan. Can she be sued in California for debt she had in California?
no, because the creditor needs to have personal jurisdiction over the consumer. That means that they need to sue her in Michigan because that is where she resides since she left California and no longer lives there. So hypothetically speaking, the lawsuit would probably boil up into Michigan. Again, I am not a Michigan attorney, nor am I a California attorney, so I cannot tell you how that statute of limitations will be applied. But I think Michigan is where you would be sued if they decide to sue you. So that
Right.
is where you reside.
Right. Uh, Great. And that being said, Kim, right? Can't is a difficult word a little bit, right? So they can sue you. Should they like win the lawsuit if they sue you in that spot? Uh, probably not. Should they sue you somewhere else where you live? yes, but the only way that anything is going to be done about that is if you bring it up to the judge.
Correct. Again, you need to advocate for yourself. You either need to hire an attorney or go to court and explain to the court that you have looked into this and you believe that the debt is out of statute if the statute in California is 4 years, and have the judge make a ruling on that to decide if the case can go forward or not. Statute of limitations is a very critical um, legal term, which means how long somebody has to sue you after a breach has occurred. So if your last payment, as you said, was in 2021, it's been probably almost 5 years, maybe 4 years since that has happened. If the statute of limitations is 4 years, as you said it was in California, you probably have a pretty good defense that they can no longer sue you because you're outside the statute of limitations. Or they, not you, but they are outside the statute of limitations.
Right. Great. All right, folks. If you have a question for us, call in at 801-613-8181. We're moving on to the next question. We have an audio recording.
Yes, good afternoon. I have a $11,000 dollar amount that I owe for an unsecured credit card, and I have been sued in court, and I have an arbitration hearing. Unfortunately, I was laid off and have been unemployed for the last few months, and I'm unable to make any arrangements now. However, I have informed them that once I am employed again, that I am willing to make future payment amounts. So I'm not sure how the arbitration will turn out. The arbitration is next month. I would appreciate your input. Thank you very much.
So that's a really great question. Unfortunately, inability to pay is not a defense. So the fact that he is currently out of work is not going to help him overcome owing the money. What he needs to do is communicate with the plaintiff's attorney and try to get a resolution via a settlement, and maybe friends, family, relatives could help him get into an agreement that he can afford, and he can make monthly payments on the debt to try to avoid a default judgment from being entered against him and garnishment actions being undertaken once he does get a job. Again, the trick to life in everything we do is communication. So explaining to the plaintiff and the plaintiff's attorney his current situation, that he is unemployed and he doesn't have money to pay the debt today, while an impediment now could be a benefit to the plaintiff and plaintiff's attorney down the road if he could find a way through family, friends, relatives to make some small payments until he's able to get employment and then start paying off the debt. By doing this, by entering into a payment plan, the consumer and the plaintiff come to an agreement, and that gives the consumer some control over how much and when payments are made on the debt. If you don't do that and just stick your head in the sand and you don't come to a settlement, most likely a judgment can be or will be obtained against the defendant, this man. And then once he gets a job, there's a chance that the plaintiff's attorney will find out where he works and start a garnishment proceeding against him if the state that he is in allowed for wage garnishments. A wage garnishment turns most people's lives upside down, because of, instead of you knowing how much and when the money is coming out of your account, it's something that you've agreed to. A garnishment takes up to, like in Ohio, 25% of your pay, every paycheck. And as you could imagine, that could be devastating to most people that live paycheck to paycheck. There's also other post-judgment remedies that could take effect depending on your state, including but not limited to a judgment lien placed on your residence if you own real estate in the state where you got a judgment against you at, as well as a bank attachment, which is also very devastating. So you put money from your paycheck into your bank account and you try to save up a little bit for a rainy day fund or for an emergency fund. This plaintiff gets a judgment against this man. If they find out where he banks at, they could file a bank attachment and take out a good part of the money that he has in the bank that he has saved for a rainy day or for emergency fund. All these things happen involuntarily. That's why at Solo Settle, where I work, we really encourage people to communicate with their plaintiffs and the plaintiffs' attorneys to try to come to amicable settlement terms that they could live with, so that they have some input into when and how much is taken out of their pay, or how much they have to pay to the plaintiff every month. That way it gives you some modicum of control, and you know that you could work that into your budget, and you know how much every month that payment will be. That's very important for so many people. They don't see that this is the long game. They just see the short game. And the short game is getting out of court, which is great. But if getting out of court means you've stuck your head in the sand and a default judgment is taken against you, that one day out of the blue, your paycheck might be garnished, the money in your bank might be attached, and there might be a judgment lien placed on your house. That could be devastating to you. So by taking control now and saying something now will pay dividends down the road.
That's for sure. Communication is key. And folks, just so you know, a good portion of solo customers report that they go to friends or family to help pay off the debt that they are in. Something that we've surveyed people on, and that's what they tell us. Also, a good portion of people will actually use another loan if they need to get back on the right track. And you have access to exclusive deals on the Solo dashboard. So if you log into solosuite.com, you just go to your dashboard, you can check it out. We have partnership with folks who can help you do bankruptcy if that's the right path for you. They can also get a loan that can help you build your credit, even if you have bad credit right now. So you can go and check out our partners like Bad Credit Loans or Kovo or Personal Loans and help yourself get back on the right track there. We have another question that I'm going to pull up now.
Hi, I was just wanting to ask a question real quick, and I have a debt lawsuit where the debt is $2,500, and I'm being sued by LVNV. I filed my answer, which was a general denial in the case, and the next thing that I got was a notice of trial, and I wasn't expecting that. I was expecting, I guess, a chance to negotiate or something, or for them to send an answer back. I wasn't prepared for the trial, so I'm just wondering, is that normal, and what I can do to prepare? Again, it's over $2,500, and the trial is set for October, I believe. So I'm just curious on what your advice on the next steps would be.
Again,
Thank
not
you.
giving this person legal advice, but hypothetically speaking, $2,500 debt is a great debt size to get resolved amicably. I know the solution to your problem. It is pick up the phone, call the plaintiff's attorney, use solo settle to try to make a settlement offer. Um, most, if not all, plaintiffs will let you pay monthly payments over 12 or 24 months. You could start with a reduced amount and negotiate up and down with them to try to get the case settled. What you don't want to do is wait to the last minute and go to court. My suggestion to this caller would be to tomorrow, not today, because it's probably past business hours, but no later than tomorrow, pick up the phone and call them, come on to Solo Settle and make a consumer initiated settlement offer, and digitally communicate with the collector if you want. Try to find an attorney to help you if you want. But what you need to do immediately is this caller needs to do is communicate with the plaintiff's attorney and get the case settled. It's a $2,500 debt. I'm sure they'll take off at least 10%, if not 20% or 25% to get it settled. You could probably make monthly payments of $150 a month for 18 months to get it resolved and put this behind you and move on. What you don't want to do, and I see this every day when I practice law in Ohio, is people have stuck their head in the sand. They didn't respond, at least she responded to the complaint, but they wait to the last minute to make an offer, and then it's too late. You need to do this now before they get a witness to come to court and are actually in the court mode. You need to call them, talk to them, or use Solo Settle. Solo Settle is a great resource. I see it every day. I see people using it every day. It is a great frictionless way to communicate with debt collectors around the country without ever having to be stuck on hold, be playing phone tag, and having emotions. It's a great resource. George and his head made this up, and it's been a great service to so many, like thousands and thousands of consumers around the country who have been sued by debt collectors.
Yeah, that is for sure. Yep. And so we always say the best time to settle is right after filing the answer document, right? So you want to respond to the lawsuit, give yourself some more time, and then you can make an offer to settle on Solo Settle. You just go on to solosuit.com, click settle a debt, get started, and then you just answer our questions. It takes just a few minutes, and then you can see what kind of deals you can get on that debt and get a settlement, start paying that thing off, and have that all behind you. So that's the best time to settle. The second best time to settle is right now. Right? You can settle anytime during this whole process, and you can just go in and get a settlement, so you don't have to go to court. I think it's not uncommon for people to be in this position, right? They think, I'm going to file an answer, and then I'm going to wait and see what happens, and hopefully the other side caves. But then all of a sudden the other side doesn't cave, and the person's like, "Crap! I should have settled earlier," or something like that. But no, the best path is to file an answer and then just try to settle after you've taken that move. We have a live caller that I'm going to plug in. Looks like I'm going to plug you in right now. How's it going? This is George.
Hi, this is Janie Mendoza.
Janie, good to meet you. What's happening?
Well, first, I would just want to thank Solicit because you did help me answer my lawsuit from Midland, and you did try to help me to do settlement before my hearing. But then on the last, when think during the negotiation, the Midland told you all that uh, that I was that they're not gonna accept anything because I'm on a judgment. Even that time, we didn't even have a hearing yet. So I did go ahead and went to my hearing, and I did file with the help again with Solicit. I did file for notice for arbitration. At the time, the judge doesn't know what to do. He said, "Okay, we'll do 60 days. Like within 60 days, we'll do second hearing." Because at that time I said I have a question about the amount, all that, and also because during that time the original creditor has the general provision for arbitration anyway. So during that time, it's from Bed Bath and Beyond, and they closed. They did file for bankruptcy because I said I've been paying on the card. What happened? But also during that time, I got sick with COVID and everything. But I know I even told the judge I did all my credit cards. I have insurance. So, but on that part, how come this one? How come what happened? So now I found out they closed the account or something, and I never receive anything from them. So I kind of like, okay. So on the second, then when I filed for the notice of the arbitration, within a month after the hearing, the Midland Credit sent me a letter, like a copy of the documents. I think they're sending to the judge, and they're saying, yeah, I said like it's okay, or something like that, arbitration. But I didn't know on the last page because it doesn't have a signature of the judge, it doesn't have a date, it's blank. That they're putting that I have to put like 30 days to initiate arbitration, and I never received any what do you call that court stamp or like original, like a court order. I only found out like, oh, there's a court order because I filed arbitration through jams, and it's been submitted. They even do a pre-mediation or like like assessment, and they say yeah, it's good. When Midland Credit submit when the jams send them the notice and an invoice, all of a sudden the lawyer said, "Oh no, she has to close this. It has to be closed this arbitration because that the plaintiff was that I was on violation of the judge order." But
Mm.
I said I didn't have an order. It's a blank. Didn't have the judge signature or anything. I even sent it through. I did all the like uploading all my documents. But then they're claiming that we have the second hearing, the one that the judge told me, like, okay, we're gonna have the second hearing, like as if like that's the time he's gonna decide about the at that time when the first reading, like about arbitration. But then Midland Credit was claiming no, that since I was on violation, that's the hearing for reviving the case. I said I never thought it was closed or got reviving the case,
Okay.
and
Hey Janie, so
yeah.
let's yeah, so thanks for sharing, thanks for giving us the spiel here. So
Yes,
just clarifying a few things. So sounds like you're being sued by Midland. You've gone
yes,
to court a few times. It's for a Bed Bath and Beyond
like,
credit card, right?
yeah, one time so far. We have a second hearing this Thursday.
Okay, yeah. So Bed Bath and Beyond, right? They went bankrupt a few years ago. I think
Yes.
I recall they had like $300 million in
Uh-huh.
outstanding liabilities under gift cards and
Uh-huh.
such when they went bankrupt. So they also provide, like a lot of people, they provide store credit cards.
Credit cards, yes.
Um,
Uh-huh.
Note to everyone, right? Usually, I mean, if you were to go through this again, you probably won't get another store credit card. Store credit cards usually aren't the
Uh-huh.
best cards. They're usually quite high
Uh-huh.
interest. Right? People like get them right there at the point of sale to get the deal, but they aren't the best cards usually. Um, and yeah, I mean, tell us more about your situation generally. Are you working right now?
Yes, actually, I'm willing to settle. That's why I even apply to you all to settle. But that's the
Yeah.
time they say no. They're not going to accept anything. They want a lump sum because they already that Midland already have a judgment on me. But I said I
Mhm.
didn't have any judgment. So with me
Right.
at that time, okay, go ahead. It's I'm gonna go anyway to the court. To the court anyway. But that's
What's
why
the
I
debt? What's the lawsuit about?
it's 5,900.
Okay. What's your income like?
It's well, actually, I even explained today. I just started working. With me is like I even when I start the hearing, I start saving. I'm working on the weekend, so I know I'm willing. to pay,
Hmm.
but I was like caught like when they say like no, there's a judgment. What judgment? I was like they're lying to like I don't have a judgment in me.
Right. Do
And
you have
and
do you have other debts that you're dealing with as well, or is this
no,
pretty much the
this
only
is the
one?
only one. That's why I was
How,
like
how'd you fall behind on this card?
that's why I got sick with COVID. And I didn't even know because I and my other card. That's why I even explained to the card. My other credit card that has insurance, I filed, so it's been paid by like the insurance or something, AccuSource or Accus something, the insurance. But this one, I said like, what happened? I even like I can't what happened in here. But during that year, like 2023, from the time that I have surgery, I was sick, but I tried. I even have the receipt on my other card that my doctor was signing. Like okay, yeah,
Yeah.
like that I was sick. So
Okay.
I was
Have
yeah.
you
So
made a solo settle yet? Have you offered a deal on solo settle yet to
yeah,
replace?
they did, and that's the one. The last part, I had the email. In fact, I'm gonna present
Who's
it to arbitration, and they say no,
who's
they're
the law
not
firm?
willing.
Who's the law firm?
Uh, a law firm for what?
Representing who's the law firm representing Midland?
Oh, they just put it. I just know the name of the because they put it Midland Credit Management, and then the lawyer is Juan Ganaga, something like that.
What state did you say you're in?
Texas, yeah,
Texas. Uh, okay. Scott and Associates is the biggest law firm in Texas, but sometimes Midland represents themselves. Yeah, what do you think?
Boy, there's so much to unpack in Janine's story. Again, I think she's doing the right things, that she is going to court, she is communicating with Midland. I'm surprised that they don't want to try to settle with her and take a discounted value. It sounded to me like Janine was offering to pay something on the debt because she owes it, it sounds like. But I'm kind of surprised at Midland's tenacity with this case and about why it's going the direction it's going. Janine, the most important thing to do, and I think you're doing it, is you need to go to court on Thursday, which is coming up, and advocate for yourself and explain to the judge what you've done, what you've try to do, and try to get him to help you convince Midland to take a settlement that you can afford and make either a lump sum discounted payment or payments on a discounted sum, monthly
hmm
payments on a discounted sum. I think that would be a win-win for you. Um, they
I,
don't
I,
want to go to court.
yeah,
You don't want to go to court.
yeah,
That's really the true trick to debt collection is, as George has taught me, both parties want the same thing, a quick settlement as fast as possible. So I would still keep banging that drum. I would, I would suggest to you, I can't give you legal advice, of course, but I would suggest to you that you talk to the judge and you tell them, I want to settle, and they just refuse to respond to my offers or do anything, and see what he can do to help you maybe
it's a,
get to a
yeah.
win-win where you
Uh,
pay something and they're willing to accept what you're offering. Because I think
and yeah, and the thing with me is the reasoning with me with the arbitration. I feel like like I'm willing to settle, but at least it's not on a courtroom. Like I could it's kind of like not formal, you know
yeah.
and the things like, and now they're trying. I even submitted I a complaint to the consumer because initially they lied that they say that there's a judgment on me when I was trying to settle. And then now they're saying that I have a court order. I didn't have a court order. The one that copy that I got is there's no signature of the judge and it's no date. So how do I know what's the 30 days? Kind of like that.
Well,
But
bring
they're
that up
clear.
when you see the judge on Thursday. Bring that up to him and say, "This is what I
Yeah.
got, and it wasn't complete."
Yeah,
Um,
it's Janie. What you're describing is a tactic that we see quite a bit. It is legal, and it is like a fine tactic. What Midland's doing is they're sending you documents that they're proposing in court that haven't been
Uh-huh.
finalized yet, right? So they'll send you like an order for default judgment or an order for judgment, It's not signed. Like, it looks like a real document because it is a real document, but it's not signed by the judge. It's not finalized. They're just proposing that, and it does scare people quite a bit. But it's not a finalized order like you're saying. So you're totally on point there. Yep, and you definitely want to show up in court, and hopefully they'll settle before court. What's your latest offer like? What have you offered on this thing?
Well, the last time I think is at the time the last offer that I was trying to sell is like 3,500.
Okay.
On a $5,000 debt?
Yes.
As
Yeah.
a lump sum, as a single one time lump sum.
Yes. Uh-huh.
Yeah, I think you're definitely in the right mindset there. I would ask them to make a response to your offer and see if they can come down a little bit and try to meet in the middle. I think
Yes.
that'd be a win for you.
Janie, thanks for coming on.
Thank
Go
you.
ahead and
Thank you so much.
go ahead and send
You're
your
welcome.
email address to Hannah on the line, and we can go ahead and take a look at your account and help you out further to make sure this thing
Yeah.
gets wrapped up for
But
you.
also thank you because you helped me. I did the answer. In fact, the judge was, like kind of surprised that I have like a formal answer. And then with the what they call the arbitration, even the judge again, it was like, oh, that I think the judge even got surprised that I was asking for arbitration. But it did help me a lot.
Well,
Okay.
good.
Yeah.
Thank you.
Glad we could do the answer. Glad we could do the answer for you. Thanks.
Was there
All right.
somebody
We have one more caller coming on. We are ready for the next one. Looks like I'm plugging them in now. How's it going?
Good. Is this for Robert?
Yep, Robert. How's it going? This is George.
Hey, George. Thanks for taking my call, guys.
For sure.
I do live in Ohio, and I'm being sued by PNC Credit Card for about 15 grand. I fell behind on a lot of my payments. They're just one of them. Um, I basically borrowed too much money. I had pretty good credit, and I borrowed a lot of money for an investment that is still yet to be paid out. So I fell behind on a lot of my payments. I've paid off some, the lower ones, and the bigger ones had I couldn't pay the payments anymore. I did recently pay one off by refinancing my house. I paid off a $26,000 credit card by refinancing my house. So that happened recently. But the reason I'm calling is I'm being sued by PNC Bank, and I initially did a response back to them with the solo document, and they, from what I can tell in the paperwork, they said they've never received anything from me, no acknowledgement or anything, which is a lie. And it has gone to the Franklin County Common Pleas Court, and it basically said the judgment is against me and approved, and I'm basically guilty. But there's never been a date, a court date, or anything on any of the documents they've sent me, to show up in court or anything. So I don't know what's going to happen next. It's from this Zwicker and Associates out of Independence, Ohio. They're a debt collection law firm, I guess. And what kind of stinks about it is I had a PNC home equity line of credit with them, and once I started going default on this credit card, they stopped my line of credit from my house. And I called them up and I asked them. I said, if you turn my line of credit back on, I will pay the $3,000 that I'm behind in payments, and we'll be back on schedule again, and I can start making payments again. Well, they denied that and didn't want to do that. I guess they didn't want to extend me any more credit for some, I guess for obvious reasons, but that would have settled, or that would have gotten me back on plan again, but they didn't want to do that. So, I did the solo letter, and then they're basically acknowledging that I never replied to us, and then the court says I'm guilty, and I owe them now $17,000 with filing fees and extra court costs and all that stuff. So now I owe them like 18,000 now. It looks like.
So can
Go
we
ahead.
unpack this a little bit? When you say the solo answer, I mean the solo letter, do you mean the solo answer?
Yeah, the acknowledgement for that I had to reply back to the initial letter that I got, so I did that through Solo.
Correct.
And
Have you checked the Franklin County Common Pleas Court Clerk of Court's records to see if that answer was actually filed in the case?
I have not done that. No.
I am going to put in the chat, if I can, link to the Franklin County site. George, I'm sending it to you. Can you send it to Robert and make sure he receives that?
For sure. It's on the YouTube chat here, Robert.
Okay, it's on the YouTube chat, Robert. It's up there at the top of the page. If you click on that, it will take you to the Franklin County website. I live in Franklin County, so I've used this site many, many times. At the bottom of the page, you could click accept, and it will get you in there. You can type in your name, your last name, first name, and you could see what's going on with the case. I think that's the first thing I would suggest you do. You need to make sure that that answer was filed. If it was not filed or was filed in the wrong case, you need to go down to the court and write up something called a motion to vacate judgment saying you did try to file the answer, but that it was not properly filed.
Yep. And so, Robert, yes, with this, right? So it sounds like you use Solo to do the debt answer. You want to make sure that you didn't accidentally do like a debt validation letter or something else like that. You want to make sure you did a debt answer. Our answer is highly accepted by courts. That said, sometimes things happen. The error rate in filing answers for us is less than 0.05%. So it is widely accepted. If there ever is an issue, we just refile for people automatically for free. So if they're, again, talk with Hannah after this call, and we can get you further support on here to double check to make sure that it was filed correctly for you.
Yeah,
Oftentimes,
that's the one that costs like $29 or something. That letter.
It sounds like maybe you did a debt validation letter. Yeah, that one, we don't offer that letter anymore, but it used to be $29. Yes.
Yeah,
Yeah.
that's the one.
What you needed to file was something called the answer, and the answer is a response to a complaint.
Yep.
We have lots of blogs telling people about answers and explaining to them why it's necessary to file an answer to avoid a default judgment from being granted. How long ago do you know when the judgment was issued? How long ago was it?
I'm looking at it right now, and it's stamped July 24th.
Oh, so it's only been 30 days. I would suggest you go to Solo Settle or Solo and see if you could do a motion to vacate judgment. We have a product called Solo. Ask Solo that will help you use AI to draft a motion to vacate that judgment and try to get a second bite of the apple. It might work, it might not work. You need to provide them, Robert, with some specificity as to why you didn't file an answer with the court. Maybe you could tell them that you were confused that the debt validation notice that you sent was the same thing as an answer, which it's not, unfortunately. Do you know what's the case number? Let me look up your case. Do you have the case number on the top right of the case?
24 Charlie Victor 009609.
Yeah, so Robert, I'm showing you here on the site. So you can go on to solicit.com and just click Ask Solo. You can have Solo AI create the document for you and get that all taken care of. So you'll want the motion to set aside judgment, and then you also will generate an answer document, and then you can get those all filed in the court. And that's the rundown there. The good news for you is that motions to set aside judgment are pretty much always accepted. On like some rare occasions, the judge won't accept them, but pretty much always that's accepted, and they'll take your answer document.
Okay, it says this is a final and appealable judgment.
Right. That's what they say once they get a default judgment is issued. That is very common language. I do see that they filed a default judgment on 6/11 and that they granted the motion on 7/24/2025. So that's what happens when you don't respond to the complaint. That default judgment happens. We have lots of blog articles that you could come onto solosuit.com and look at, and we have articles about motions to vacate judgment. We have articles on how to file an answer and why it's important to file an answer. I would go on our site, review those documents, and see what you could do to help yourself get out of this hole.
Yep, and people settle with Zwicker frequently through Solo. They're one of the largest debt collection law firms in the U.S. We also see people resolve cards with PNC. Bummer about the home equity line of credit. Totally feel you there, right? You could have paid that off and done it at a lower interest rate. But all's not lost. So you just want to do the motion to set aside judgment and then get that
So
answer created and filed.
after that, if they do the vacate judgment, then what would happen?
Okay.
I'd all at the same time send them in an offer on Solo Settle to pay off the debt at some kind of a discount.
At some kind of
Yes.
discount.
So Robert, the trick is communication. You need to use Solo Settle. You need to pick up the phone. You need to find an attorney, but you got to communicate with the plaintiff's attorney to try to get the case settled. It is in your best interest to settle the case because settling for 80% is so much better than getting a judgment taken against you and having a lien put on your house and maybe a wage garnishment filed against you in Ohio, which would
be we usually see people pay at least 70% extra when they don't settle, and they just try to go on and end up losing the lawsuit. Robert, what's your investment? What's the investment that you've been making with this capital?
With crypto.
You've been taking out credit to invest in cryptos?
Yeah, for quite a few years now, and it wasn't a traditional way, and it was Bitcoin to make more Bitcoin, and basically mining of a company was mining Bitcoin, turn 1 into 2 or 3 kind of thing. And
was it mostly Bitcoin you were buying, or anything else? Buying any
no,
Ripple?
mainly Bitcoin. Yeah, it was all Bitcoin.
Okay, well, hope that turns out for you. I think you probably know this at this point. That's a very high risk move. Taking out credit to invest in.
I took a huge gamble. I realize that, and it just I was hoping to get some return way before this, and I wouldn't even be in the situation I'm in. But I did the best thing about borrowing money to invest. I know that's not the way to do it.
Well, hopefully this can pan out for you still, and you can get out of all of this debt and get back to positive net worth. All right, Robert, thanks so much for calling in. Appreciate it. Glad that we can help you out.
Yep. Thanks, guys.
You're welcome. Thank you.
Alrighty. Yale, how about you? Are you taking out credit to invest in crypto, Yale?
For good or for bad, I have not invested anything in crypto yet. I don't think I don't plan to.
I'm definitely buying cryptos personally, but not on credit. Definitely want to avoid that, folks. Definitely want to avoid that. Sometimes we gotta learn the hard way. That's for sure, unfortunately. But I hope Robert gets out of this hole. I just look at the numbers on Bitcoin, right? It's been the best investment over the last 2 decades.
Yeah.
Right.
It is a gamble.
Okay, folks, we have time for 1 or 2 more questions here. After we have a question from Shirley in Tennessee. After settling with the debt collector, how is the best way to clear it off your credit reports?
Well, after 7 years from default, most debts come off your credit report. That's typically the easiest way for it to come off. Your credit report is 7 years from the last payment date.
After
Or actually the first default. So once you default, that's when the clock starts ticking.
I think Shirley's thinking that after she settles it, the collector will remove it from the credit report. Is that the case? Is that what they're supposed to do? Or are they just supposed to leave it on and say that it's been settled?
They're supposed to make some notations on their credit file saying that the account is paying and or settled.
Right.
Some people do that, some people don't.
Yep, so that's the right idea, Shirley. And it is the creditor who does that. It's not the collections law firm, or it's the person that owns the debt. But they aren't actually supposed to take it off of your credit report, right? So after you pay it, they aren't supposed to take it off your report. They are supposed to mark it as settled or paid in full.
Or settled for less than full balance.
Yeah, exactly. It. All right. Last question. We have a question from King Arthur in the chat. King Arthur, if you're still here, let us know if this is legit. He says, I have $135 million in credit card debt. Should I just let it go to collections?
You really think we could have $135 million in credit card? Maybe
I don't know.
maybe for him it feels like $135 million, but that would be some spending spree.
135 million, King Arthur. That is a lot of money. Hopefully you get that wrapped up. I wouldn't at any point in time you can try to settle it and get that paid off. Let's see. Okay, folks, that is all for the questions today. This is the Debt Hotline. Thanks for showing up and watching the show. Thanks so much for coming on, Neil.
Yep, George, always fun. Happy to do it. Hopefully we help some people today.
Alrighty, folks. Stay tuned for our next $4,700 giveaway starting soon in the month of September. You will be able to enroll and sign up for $4,700 giveaway. So stay tuned for that. You may be the lucky winner of $4,700.
Awesome.